Suppose I should have told him 30 minutes, but anyway, maybe not. Do you have any motions at this time, Ms. Bright Matthews?
Yes, I do, Your Honor.
I'm happy to hear them.
The defense would move at this time for a directed verdict. This verdict is based upon the state's failure to show a prima facie case of arson, the elements of arson, and the elements of murder. They have not established, even by circumstantial evidence, that this defendant set the fire, nor have they been able to establish that he committed a murder. Of course, unless they can establish the arson, they don't have the murder. I understand the state's position on some of these issues as circumstantial, but they have failed to establish the essential elements. Excuse me. The essential elements of murder, that there was an intention to kill, that he did it with malice aforethought. They have failed to establish that the arson was an actual act intentionally by Craig Lewis. We have received no information or nothing from the stand from the state on any of this. None of the officers, no experts, no one has even been able to put Craig at the house at the time the fire started. And on that basis, the defense would move for a directed verdict.
Thank you so much.
Thank you, Your Honor. At this stage, of course, the court is concerned with the existence of evidence, not the weight of the evidence, and the facts are taken in the light most favorable to the state. Regarding the arson and the murder, this is a circumstantial case. However, the defendant actually places himself at the scene of the crime. He is with Terry Lewis when he states that she tries to light a fire and it blows back on her. This takes place the night after a domestic incident that was witnessed by her daughter, Leanne Kellum, where allegations of cheating were alleged by Mr. Lewis, where he says she now gets nothing. Well, what better way to ensure she gets nothing than to kill her? He does not call 911 for help. All of the cleaning that he is doing when police get there, the fact that he cleans himself up before taking her to the ER, the fact that Terry's clothing is not found, there's missing evidence, there's circumstantial evidence that he has manipulated the scene, removed a burned couch, cleaned up fire debris, and gotten rid of Terry's burned clothing. It is the state's theory, and we do have circumstantial evidence that Mr. Lewis, in fact, did either light Terry on fire or light the couch on fire. The couch is burned where Terry habitually sat on the left side. If you look at the scene, the story that he tells makes no sense. There is burned, what appears to be burned clothing debris or what have you on the outside of the doors of the stove. There is nothing on the inside. Had the doors been open, it would have been there. Presumably the doors would have had to have been open for there to be some sort of blowback explosion. Not to mention, there is no charring, burning of anything around that fireplace. There's a gray chair that is right next to the fireplace, on which a bucket sits atop. None of that is burned. There's actually a photo, an unframed photo, a paper photo to the left of the fireplace that's not burned at all. And somehow Terry is burned all over her face, all over her chest, all over her legs. and primarily on the right side. Now, if she is sitting on the couch where she typically sits, or if she is laying on the couch where she typically lays, that would be the side that is exposed to someone that could possibly light her on fire. The arson statute indicates that a person willfully, maliciously causes an explosion, sets fire to, burns, or causes to be burned, or aids, counsels, procures a burning that results in damage to a building, structure, or any property specified in subsections B and C. Going down to subsection C, which is to include personal property. Personal property would be that couch. For it to be arson first, serious bodily injury to a person, or death results. We do have serious bodily injury that actually did result in death, and that is pursuant to South Carolina Code 16-11-110. As you well know, for murder, malice can be formed in an instant. I do think that we have ill intent and malice, evidence of that occurred the night before, as well as lighting someone on fire. While this is certainly circumstantial, the defendant places himself there. There's nobody else there that could have done this besides Terry herself. And that is refuted by all of his actions that take place prior to and after this incident. Thank you.
Thank you. Anything else?
Nothing from the defense.
All right. Thank you so much. I believe there is the existence of evidence, circumstantial, but definitely the existence of evidence that support going on with this, and I respectfully deny the motions on both arson and murder. Did y'all want to take a quick break before we start?
Yes, I have my first witness on the way.
Okay, and then I can go ahead and go through the colloquy with Mr. Lewis about testimony or not. Do you
Yes.
want to do that before, or would you like to take a break now?
I would like, we can do it, it doesn't matter. It's whenever the court wants to do it.
Well, why don't we, since we've got a few minutes before we can begin anyway, if you've got someone, we'll just do it right before we bring the jury back in. Does that suit everybody? So we'll take a quick break now. If you would let the jurors know that they've got a few extra minutes. So. Okay. All right, thanks.